Good afternoon, Your Honor. I'm Hodges on behalf of the plaintiffs, two of whom are in the courtroom today, Mr. Hamilton and Mr. Carter.
Good afternoon. Welcome.
Good afternoon, Your Honor. Assistant U.S. Attorney Keith Stout on behalf of the fellow defendants.
Good afternoon. You both had a chance to review the tentative?
Yes, Your Honor. Yes, Your Honor.
But Mr. Hodges, I think I'd like to hear from you first, please.
Your Honor, first of all, let me concede a point raised in your tentative that this is not your usual Bivins case. That's clear to everyone, I think. As a housekeeping matter, I would indicate that on page 1 there is a typographical error. In the middle paragraph, the administrative law judge finding was in 2005, not in 2010.
Thank you.
Having said that, let me turn to the second issue raised by the government first. And that's the question about whether or not there are property rights at issue in this case. And very simply, what we have alleged is that, and let me back up a second. We have alleged a scheme, in effect, that is a sting operation judged from the outside and not from the inside. Basically, the sting operation was an operation put into effect through the Department of Homeland Security, the Department of Justice, and the SEC commissioners. What we have alleged is that the SEC commissioners, as opposed to the agency itself, coordinated with these other institutions and at their request and in concert with them began a program whereby this company was raided. And the SEC Commission was fully aware at all times of the amount of naked shorting that was going on in this company. The then chairman of the commission has been quoted on several occasions as saying this was the most heavily naked shorted company in the history of the world. As we have alleged in our complaint, on one day, which I believe was sometime in April of 2005, some more than 90 billion shares of this company traded in one day. I have testimony from, which is not alluded to in our current complaint, but I can provide testimony from registered NASD companies that were in business at this time who report that they were told it's free money. You can sell as many shares as you can find buyers for and put all of the money in your pocket. You don't have to ever buy the shares. They were on a no-borrow list to begin with at that point in time, which was in 2005 primarily. And if you were going to borrow shares as a legitimate broker at that point in time, they had a $2.50 requirement for buying or for borrowing. You can imagine with some, I think the average during that period was 17 billion shares a day being sold. This is an enormous amount of money for people to be borrowing shares to sell to the market. They were being sold for nothing. That's how they drove this company into the ground. They did it because there was evidence by the government and by others associated both directly and indirectly with the government that this money was being sent offshore. It was being accumulated by hedge funds offshore. It was being sent to Iraq. It was being sent to Iran. It was being sent to Afghanistan. It was being sent to Hezbollah. This is one of the means in which these terrorist organizations were utilizing to fund their operation. Having said that, I recognized when I prepared this complaint that at the time the company was delisted, we didn't, and the time that this original agreement was made, we did not have a basis to sue the SEC commissioners, or anybody else Because, in fact, as the court correctly points out, in that regard, the Braun versus Elastic case, I think, says that shareholders don't have a right. They don't have a property interest. They did not have that right at the time the agreement was made, and at the time the original ultra vires criminal acts by these commissioners took place. However, what this complaint speaks to is at quite a later date, after the company was delisted in October of 2005, and they stipulated to that delisting. Then we go forward, and what immediately happened was a task force, including one of the primary and past board of director members, Mr. Bob Mayhew, who is no longer with us, unfortunately, became the head of that task force. His appointed duties and the task force appointed duties were to have the shareholders pull copies of their shares, pull certificates for every share that was legitimately been owned because it had been bought and paid for. And based upon that share certificate pull, to then turn around and liquidate the company. At the time that the company decided it was going to liquidate itself and distribute its remaining assets to its shareholders, the property rights attached to each of the shareholders. Because at that point in time, which was in early 2006, they had a right to believe that what was in their future was a distribution, a pro rata per share distribution of the assets that the company then owned. The company then owned all of these monies that had been accumulated and put into trust. The company also owned shares of stock in a company called Entourage, and they had other assets. They did not have any substantial liabilities. So the shareholders, from that point forward, had a property right that is protectable under the Constitution. It is that claim that we are making in our complaint. Having said that, once we get past the property right issue, I certainly understand the court's concern, and I've reviewed my complaint about perhaps the use of some inartful language when I referred to the SEC rather than specifying that it was the SEC commissioners that we are aiming this at. The reason we're aiming only at the SEC commissioners is because under the statutory scheme that was set up after the first Great Depression, the SEC commission and the commissioners individually have the sole and exclusive right to make the decisions. For example, when this firm, when this company was delisted in October of 2005, it was pursuant to an administrative law hearing that took place here in Los Angeles, full day down in federal court that I attended. And the administrative law judge then rendered a tentative decision. It was her decision, but it was tentative in the sense that it had no power, it had no effect. The only time that it became effective and the company became delisted was on October the 24th or 25th of that year, when the commission met and together agreed that this company should be delisted. They are the only people who have the power to make these kinds of decisions. They are the people who spoke to the other governmental agencies and to the people representing, at least ostensibly, the company at that point in time when this agreement to utilize this company without knowledge of the shareholders and part of a sting operation to trap all of these hedge fund people that started way back in 2004. But it was those commissioners acting in an improper and ultra-virus and probably criminal way because their mandate under the law is to protect shareholders. They were doing exactly the opposite. They were entering into an agreement they knew was going to damage the shareholders, was going to drive this company out of business, which it did, and without notice, in a big secret. And it was only those commissioners who took that action that we're aiming this complaint at. We have named the commissioners